Yes, sir. Yes, sir. Go ahead.
Okay, Ganesh, please start now.
Okay, sir. A very good afternoon, one and all present here. I, Ganesh Ekade, on behalf of Manikchand Pahade Law College, Aurangabad, take this privilege to warmly welcome you all on the fourth day of 1 week online lecture series on jurisprudence. We have reached to the fourth session of 1 week online lecture series on jurisprudence, and we are honored to have with us Dr. Tejaswini Malegakar ma'am as the resource person for today's session, who will be guiding and enlightening us on the topic American legal realism. I would like to introduce today's resource person. Dr. Tejaswini Malegakar ma'am is an academic luminary. She has completed her master's degree in business law and administrative law with a gold medal from Pune University and completed her doctorate on women's issue in India. Presently, she is working as an assistant professor in ILS Law College, Pune. Ma'am has teaching experience of more than 18 years. She teaches subjects like constitutional law, jurisprudence, administrative law, human rights, and international law. Respected ma'am has delivered lectures in national and international seminars and conferences on the topic protection from sexual harassment at workplace, concept of human rights and its various dimensions. Ma'am has written many more than 25 articles on diverse issues of law, to name sexual harassment at workplace, feminist jurisprudence and right of women, international standards and dimension of human rights doctrine, published in International Research Journal of Humanities and Environmental Issues. Uniform Civil Code Issues and Challenges, published by the Bar Council of India Trust, India Bar Review, Volume 32. A Right to Life and Personal Liberty, Challenges and Judicial Response, published by Bar Council of India Trust, Bar Review, Volume 30. Child Right Fortification, Determination of the International and Indian Communities, Legal News and Views, published by Social Action Trust, New Delhi. Honorable Ma'am works for the Legal Aid Center of ILS Law College, Pune. Recently, she has written article on right to disconnect, names as Working Relentlessly, Do We Have Right to Disconnect, which was published by Social Action Trust, New Delhi. Ma'am believes that education is not preparation for life, education is life itself. We are glad to have such an eminent personality for today's session. On behalf of MP Law College family, I welcome you, ma'am. Before I request to the ma'am, there are few instructions for the attendees. If you have any questions during presentation, please type them into the chat box. Your questions will be answered by the ma'am at the end. To keep the quality of sound functional during the session, please mute yourself when you are not sharing. Now, may I request Dr. Tejaswini Malegavkar ma'am to kindly enlighten us on the topic American legal realism.
Thank you so much. Thank you, Ganesh. And thanks to all the college authorities for inviting me. Okay. To begin with, I would like to share my screen. Sir, please can you tell me whether you can see the screen or not?
Yes, ma'am. Your screen is clear.
Okay, thank you so much. First of all, before starting with this topic on American legal realism, I would like to share that I have learned this or jurisprudence from my guru, Dr. Dilip Uke. So I would thank him first for giving us such knowledge. And because of him, today I could speak on this topic, which is related with American legal realism. Now, this lecture series is on jurisprudence. Now, jurisprudence, if we see the Latin word, it is known as jurisprudentia. And juris means law and prudentia means knowledge. So it is the knowledge of law. So to gain knowledge of law, we want, or if we want to know about law, then, or to gain the knowledge of law, we should know not only the text, but we should know the context. So the context is what? The context is something in which we find it is related with socio, economic, political, sociological, historical, and geographical background. So in every law, not only the text, but the context is very, very important. So in jurisprudence, we study certain theories, and those theories are related with the context. Okay? And each theory, we know that it differs from each other. Even the jurists, they differ from each other depending upon their own perception, what law actually is, and law is not that. Here, when we speak about American legal realism, it says that law is not that whatever is enacted by the competent legislative body, but rather law is that what judiciary decides law to be. Okay, so that is very important. So jurisprudence is actually there, or the approach of jurisprudence is to tackle leakages between other laws. Jurisprudence, we know it is stated that it is the mother of the legal education. And therefore, we know that to study jurisprudence, what we require is we need to study the context. Okay? So the context is very important. So for example, when we already have learned through this lecture series various theories which are developed. So we know that we have learned about natural law theory. We have learned two important principles which are laid down under the natural law theory, which speaks about the inalienable rights of the individual, or which speaks about the universal order governing all men. Or if we have learned about natural law theory, and also in the ancient period, or right from the ancient period, we have learned that it was developed by Heraclitus, it was developed by Socrates, Plato, Aristotle. And then we come to the medieval period, where we have learned about natural law in the medieval period, where we have learned about St. Augustine or St. Thomas Aquinas, where St. Thomas Aquinas says that this herein it is where the Hindu philosophy is been reflected. And then we know that we have learned natural law in the Renaissance period, where we have learned about Hugo Grotius, John Locke, Rousseau, or Thomas Hobbes. Okay? But as a reaction to this theory, to natural law theory, there was a theory which was developed, which is known as positivism. Now, positivism, wherein positivists stated that law is that which is enacted by the competent legislative authority. Now, this was developed by, of course, Bentham, then John Austin, then even H.L.A. Hart. Okay. But Bentham outrightly rejected natural law theory, and he said that law is something which is only enacted by the competent legislative authority. Then we had the theory which was developed, which is known as Sociological School of Law, which is known as social engineering theory, which I believe yesterday only you have learned about it and you have heard about it. So Professor Roscoe Pound speaks about the interest of the individual. Now, we have to see American legal realism was developed as a reaction to the positive theory. So law is not that which is enacted by the competent legislative authority, but law is that which is understood, interpreted by the judiciary. So the main aim of the law is to inject, the main aim of the law is to infuse certain social change, and which is a positive one. How we could explain this? When we look at Article 21, which has brought a sea change, which is the product of judicial decision making, why procedure established by law means due process of law, as judges have read it in absence of it. Why we speak about Article 21 as a reservoir of ordinary rights? Why do we say that there is a doctrine of invisible rights? How there were cases which were related with compensation, how there were cases which were related with pollution-free environment, and many more cases which we are going to discuss ahead, wherein you can find that the law which was enacted by the competent legislative authority was not sufficient one. It means it was insufficient one, and therefore, as a reaction to the positive theory, there was a theory which was developed, which is known as American legal realism. Okay. Now, why do we say that right to live with human dignity has become important? Why do we speak about right to livelihood? Why do we say that right to life does not include right to die? Who has stated this? There is a sea change which is brought by the judiciary. Okay, and that's why American legal realism's theory is based on the judge-made laws or by the judiciary. So the jurists over here, they aim at or pointed out what is the job of law. We know that it is the connection which is there. This theory has got the connection with the social engineering theory. Because law should aim to maintain the balance in the society. Law should, while learning social engineering theory, you might have learned about the individual interests. So the individual interest is of paramount importance. And for taking care of the individual interests, we have the laws to be interpreted. And those laws are interpreted by the judges. So those man-made laws were found insufficient one. There was a new thought which was emerged due to industrialization, which was rather where you can find that which was taken place, and the nature of the country was such that where you can find that the laws drafted by the legislators were absolutely not able to solve the present problems, and therefore the judges, they had to go contrary to the statute laws, and they have to enact I would not say enact the laws, but they would rather interpret the laws. Now, whatever reality exists in human society, law should react to that change. So like, for example, when you speak about Dowry Prohibition Act, okay, so law has changed a lot in case of Dowry Prohibition Act. Or for example, when you speak about the most important factor which we speak about, which is known as when we speak about separation of the husband and wife. So the law which also says that no compulsion to wife to live with a husband whom rather the wife hates the husband. If the wife is going to hate the husband, then she can be separated. Now, who interpreted this? These are all the things which are interpreted by the judiciary. Now, this law was developed in United States of America. The Supreme Court as well as the federal court in United States, which went on contrary to give a decision against the statute. And that's why we have heard about the case which is known as Mulberry versus Madison. Now, US Supreme Court stated that established principle, where you can find there are established principles which are there, wherein can there be a judicial review? And it was in Mulberry versus Madison, where it was held by the Supreme Court of USA, where they stated American courts have the power to strike down the laws. They have the power to strike down the statute and also some government actions that they find that those actions could violate the Constitution of the United States. Now, that's why you can find that judiciary decided to review the laws, the statutes, and the government actions. So it is not the law which is enacted, but law which is created, law which they thought it is appropriate, which is taken into consideration. Judiciary took upon itself as a role of the protector. Judiciary came out as a role and played the role of the promoter. So the new idealism was formed by the way of American legal realism. And this new legal realism had emerged to meet the conditions, the needs of the societies, as well as the realities which were existing in the society. So therefore, American legal realism intended to take the realities into account, and they started responding to the changing needs of the society. Okay. So, for example, we all know that while learning about Dowry Prohibition Act, we have heard about that Section 2 says that giving and taking dowry is punishable. But there is a small proviso which is laid down under the law itself. And it says that if it is not extending the financial position of the bridegroom, then it is not a dowry. And this interpretation is given by the judiciary. And judiciary say, what is the meaning of the term bridegroom financial position is not extended? So that is something which is a thought which was given by the judiciary. Or a very simple example where I would like to say that we know that from doctrine of locus standi, we came to doctrine of public interest litigation. And where we know that every now and then there started this concept of public interest litigation. So for your rights, somebody else could also go and approach the courts of law. For the betterment of the society, somebody else could also go and approach the courts of law. And the number of people started approaching in the form of the public interest litigation. And and then Justice Kaju stated that for every ill, PIL is not a pill. So the guidelines then came regarding the public interest litigation. Who can file a public interest litigation? Under what situation you can file a public interest litigation? And what are the formalities, the guidelines which are to be followed when you are approaching the courts of law under public interest litigation? So that became so much so important that where you can find that that is the reason we know that how public interest litigation entered into and how judiciary took a part and played a major role. Now, American legal realism, as I told you, it was developed as a reaction to positivism. Positive law, which is enacted by the competent legislative authority, was not sufficient one to solve those problems. American legal realism says that law is that which is interpreted by the courts or judiciary. Law could be interpreted in different ways. There was a case in the United States of America, which is known as Dishani's case. Husband and wife, they used to fight every day. They used to beat their child, the only child. And the good neighbor took the cognizance of this and approached the courts of law. And otherwise, the court would have stated that, and also the contention which was there by the parents were that he is our own child, the biological child. Whatever we want, we could do with him. We could hit him, we could beat him, and let him cry. We are not worried about that. But the good neighbor took this case up to the Supreme Court, and where the Supreme Court of America stated that it is the rights of the child which is very, very important, okay, which should be taken into consideration. And if the rights of the child are to be protected, then we should not see that who has come into the courts of law. Look at the tender age of that child. And then the new law which was interpreted, the new law which was established, and rather we could say that a new dimension which was given to the rights of the children. So this is also one more important case which is there. In India, we have heard about one important aspect which is known as right to sleep. So there was a case which is known as in Ramlila Maidan versus Home Secretary Union of India. So wherein Supreme Court explained that what is the importance of the term sleep. Sleep is necessity and it is not a luxury. Okay. Why the sleep is required? It is necessary for optimal health of the person. It is necessary for the happiness of the person. It is necessary because otherwise the person could get affected with the quality of life, and therefore sleep is the biological essential element which shall be kept in mind. It helps the emotional balance. It increases the creativity. It increases the vitality, and therefore sleep is the biological essential ingredient. Ingredient is the word which is the basic necessity of life, is being stated by the Supreme Court of India. So was it possible? Is it written somewhere under the Indian Constitution that what is right to sleep? No, it is developed. It is interpreted. Law is interpreted. Right to sleep became a fundamental right under Article 21, which was interpreted by the judges. And that is American legal realism. But now the question arises, what is that law? Law is not whatever has been enacted, understood, but rather law is that what judiciary decides to be. And of course, law decided by the judiciary will be definitely a different one, will be definitely bringing a change in the society. So let's see a difference in Gopalan to Maneka Gandhi, the journey which we have always looked into. And we know that in Maneka Gandhi's case, where the judges have stated how the law should be, the law should be just, fair, and reasonable. But that is not important. What is important is that along with that law, the procedure should also be just, fair, and reasonable one. So that is something which is to be taken into consideration. So the procedure is also connected with the law. So you see that none of the words under Article 21, they have undergone a change. But still you find that each and every word is interpreted under Article 21, interpreted by the judiciary, interpreted by the judges. And definitely we find that the interpretation is a very different interpretation, where you can find that you might have heard about Aadhaar case also. So whatever is the law on paper and whatever is decided by the judiciary, words are the same, but the content has undergone the change because of the context. Because context means socio-economic, political, geographical, historical. These are all the aspects which has an impact. And that's why you can find that the context has undergone a change. So Justice Krishna here says that what is the content? Content means implied rights, invisible rights. We cannot read them. We have to go beyond the black letters of the law. And then once we go beyond the black letters of the law, we understand the context. Like for example, when you speak about Sunil Batra's case, okay, why the writ of habeas corpus was issued to stop the inhuman barbaric treatment which was given to the jail mates. We have learned about Hussein Ara Khatun's case, why it was decided by, I think so, Justice Kuldeep Singh. So here you find that these are all the elements which plays a very major role. Now let's understand why realism. Realism, because of its approach to study law in its actual working and effects. So whatever is the law enacted is interpreted with the present situation. Like for example, do you remember Nirbhaya's case, where they wanted to lower down the age of the child? And then there was a committee which was constituted to discuss this, that it is not only the biological growth, but also the mental growth, which has to go hand in hand, which is ultimately the reality. Because we are going, whatever is the law which is enacted, we always look into the effect of that law in the society. And that is very, very important. So that law decided by the judiciary is considered as a real law. Legislative has no place, no significance in the view of law declared by the judiciary. The realism could be seen in the form of those decisions. So that is American legal realism. But let's see who has developed this theory. Now, this school was developed by Lord Carl Levlin, Justice Jerome Frank, Justice Holmes, Justice Timpan Gray. They all have developed this theory of American legal realism. So let's look into the background. Legal realism was a distinctly American approach and the philosophy of law. Now, why there was a need where you can find that American legal realism was developed? Since it was developed in America by the judges, therefore it is known as American legal realism. Now, what was the need? Because this thing was that the society in America is developing fast and faster. They are the developed nations, where you can find that the law which was enacted by the competent authority was found to be insufficient one. So the attempt was done to take a hard-headed, cold-eyed look how the legal system actually operates. You have to look into the legal system, how it actually operates. And it was a reaction to the formalistic account of law in form of a mechanical jurisprudence. Now, where you can find that in case of the mechanical jurisprudence, where you can find that it was viewed as a complex system of set, and it was precise rules created by the legislature, viewed the role of judges to be simply determining which rules apply to the facts of the case. But legal realistic saw this as a distorted picture of law. And of course, there comes the role of courts in a legal system. So there was an entry where you can find that now there was mechanically don't apply, and we are going to see ahead how it happens. So Jerome Frank stated that law is what the court has decided in respect of any particular set of facts prior to such a decision. The opinion of lawyers is only a guess as to what the court will decide. And this cannot be treated as law unless the court so decides by its judicial pronouncement. So we have to find that those set of rules which are there, which are based on the prior facts. Okay? And later on, we know those facts come into picture and in reality. So let the judges interpret that law. Okay? So law as a generalized prediction of what the courts will do. It is evaluation of law in terms of its effect, because you have to see what is the effect on the society. So, like for example, when I said that about when we speak about a number of cases where you find right to health and medical assistance, where we know that we have spoken about a very famous case which is known as Hospital X versus Hospital Z. So, sorry, Mr. X versus Hospital Z, where we know that Justice Sagir Ahmad and also Justice Kripal, they held that disclosing that the appellant was suffering from AIDS, the doctors had not violated the right of privacy of the appellant guaranteed by Article 21. Whereas they said that this right is not an absolute right, and there are restrictions which can be imposed. Because the question over here was related with the marriage, and therefore the right to marry, even though it is an essential element of right to privacy, but it is not absolute. And marriage is the sacred union, matrimonial law, which provides the protection, and therefore right to marry is a right wherein you should keep in mind that more important than right to marry is your right to health. So therefore you find that there is an evolution of law in terms of its effect. What could happen? That if Mr. X could have married, he had AIDS and he could have married. What could have happened? If the doctors, if they would have not disclosed it. Just think from the other side of it. Okay. Or we know that, why do we say today that when we speak about environment, where we know that environment is wherein you can find that a huge aspect where they have taken into consideration that right to pollution-free environment has become important. Now that's why we find that it is not so that no importance is given to the legislative enactment or legislature enacted laws. Only in case of American legal realism, only judge-made laws, they are upheld, they are considered genuine, and we find that there are different judges, Their thinking is different. They have to find it out, the certainty of law, and therefore, and that law, they have to find it out with the changing society. And that's why American legal realism has been developed. You can see in this slide where I have shown that analytical positivism, so where we have laws enacted by the competent legislative authority, they are having sociological approach where we look into Professor Roscoe Pound's theory of interest, and then the outcome of analytical positivism plus sociological approach is the American legal realism. So it considers the law as it is, positivism. Law as it stands is a product of many factors. So that is a sociological approach. Now, who is the inspiration for legal realism? It is Bishop Benjamin Hoadley. I will not read out whatever he has stated, but I'll go one step ahead because of the time constraint, I think so. So where you find that what you find is that whatever you interpret, whatever is laid down by the legislature becomes important. But American legal realism has come, and it has been recognized, and it has gained force during the term of President Franklin D. Roosevelt in 19th century, which represents the latest branch of sociological jurisprudence. It is the movement or historical phenomenon than a school of thought, not a definite, coherent, theoretical system. It studies law as it is in its actual working, and what is the effect. It investigates the realities of the modern society in their relation to the modern law. And we are going to see some of the examples, how it operates and what actually how it takes place. So Oliver Wendell Holmes, he was the one who also, he prophesizes of what the courts will do in fact, and what actually the court, how do they function? Because every case is different. You have to look into the facts of the case. You have to look into the realities. You have to look into the context. You have to look into the changing circumstances of the society. You have to look into the changing minds of the people. And then the law is to be interpreted and applied. Okay? Even John Chimpan Gray, he was the exponent of the analytical tendency in jurisprudence. The law is what the court decides, what the court at that particular point thinks that this is the law which should be interpreted. And it has placed the judge in the center instead of the statutory legislation. It has changed the position. Instead of the legislators, instead of the legislation, the center over here is the judge. And the judge will interpret that reality, look into the reality, and apply all those elements, and then they will decide what could be done. Okay? So he says that take the fundamental question, what constitutes the law? You will find some text writers telling you that it is a system of reason, that it is a deduction from principles of ethics or admitted actions, or whatnot, which may or may not coincide with the decision. But if we take the view of our friend, the bad man, we shall find that he does not care two straws for the action or deduction, for that does not want to know what Manchester's or English courts are likely to do. In fact, I am much of his mind. The prophecies of what the court will do, in fact, and nothing more pretentious are what I mean by the law. So that is something which is very, very important. He was the distinguished judge and the thinker. He was described as the intellectual inspiration and spiritual father of the American realism movement. He was a spectacle of the ability of general rules to provide the solution to particular case or the cases. He rather gave the credence to the role of extra-legal factors in judicial decision-making. He defined law in terms of its consequences and what seemed to demolish the analytical certainty and any connection between law and ethical ideas. And he was the one who has sown the seeds for realism in a paper called The Path of Law. But let us understand that are there certain characteristics of American legal realism? The answer is yes. There are almost 5 characteristics. Now, what is realism? Realism means a movement in thought and work about law. So how law functions. Those decisions delivered by the judges are nothing but their thoughts. It is their vision to read and interpret the law. So like, for example, when we speak about the Indian judiciary, where they spoke about virginity test violates right to privacy. So this is what? This is their vision. This is their thinking. This is their interpretation. Judges, when they speak about right to privacy and surveillance, so this is what? This is their thinking. This is what judges have thought about it. We know that telephone tapping is an invasion on right to privacy. So this is what? This is what they have thought. This is what they have looked into, how the law functions and actually how the law should function. Or when judges, they have stated that in case of the divorce petition, husband, if he's going to tap the phone of his wife, then those evidence cannot be taken into consideration in the courts of law. It violates her right to privacy. So this is what? This is the decision delivered by the judges, which is the vision to read and interpret that law. So therefore, realism means a movement in thought. So continuously, it is a thinking process. Like, for example, when we also speak about Aadhaar case, it is nothing, but it is the movement. Because your Aadhaar number is linked with the bank account, also with the income tax documents, also with other all elements, and wherein this was challenged. So that is their vision to read and interpret that. Realism means a conception of law in flux, that is in troubled time and as a means to social end. So whenever there is a trouble, judiciary is the last resort. People actually solve their problems initially through friends, conciliation, mediation, arbitrator, and lastly, when they do not have any solution, they approach the courts of law. So like, for example, if there is a fight between husband and wife, the first thing is we try and solve our problems and discuss those problems with the friends. Then we discuss it with our family members. Then we find that no, there is no solution. And ultimately, when you approach the judiciary also takes into account the elements, and they will first of all send you for conciliation. So that is, realism is what? It is not always you are changing the law. Realism will come into picture only when there is a trouble, when there is no solution. And therefore, it is the law in flux. That is only in trouble times to meet the social ends, to fulfill the social ends, to look at the requirement of the individual, wherein you can find that the realism will come into picture. That is the time when realism will come. Like, for example, when we speak about doctrine of basic structure, it was when we were in trouble. Such kind of doctrines were developed. Or like, for example, when we speak about doctrine of notional extension, or when we speak about doctrine of eminent domain, these are all the doctrines which are developed during the troubled time, because we want to meet the social aims. Realism actually assumes a temporary divorce between is and ought. So is and ought, law as it is and law ought to be, they're separated for some time. It is not a permanent solution of is and ought, but temporary one, because otherwise they are together. So sometimes judicial decisions are based on only the provisions, that is. And sometimes they introduce the element of rationality, or sometimes they introduce the elements of morality, that is ought. Okay? And that's why we know the journey from Gopalan and Maneka, when we say that Gopalan is law as it is and Maneka is law ought to be, because Article 21 has brought a sea change, and where we know that in Maneka Gandhi's case, or from Maneka Gandhi's case, where we know that there is a sea change which has come into existence, where we know that the concept of personal liberty has also undergone a change, and therefore it is a temporary divorce between is and ought. Realism distrusts the traditional legal rules and concept. Means whatever is the law which was there traditionally. Like, for example, when we speak about doctrine of locus standi. So there came a situation where it was thought that, yes, there could be public interest litigation. That is the need of an hour. That could provide the correct remedy. That could give the correct remedy under Article 32, or where you can, or where we find that when we speak about the interpretation of the writs. So it says that when we speak about the writs, when we speak about writ of habeas corpus, it has got a specific nature, but that nature had undergone a change. Like Justice Krishna Iyer says that let the writ travel from those iron bars. Okay? So those iron bars, it is traveling, means let it go beyond the black letters of the law. Okay? Realism believes in evolution of any part of law as well as their effect, function, certain techniques of adjudication. It is not the law which is there on paper or not the procedure, but such procedure shall be evolved. Such techniques should be evolved. So that's why in Maneka Gandhi's case, where we say that law should not be just fair, but also the procedure should also be just and fair. So that is why the procedure is to be evolved. And while evolving the procedure, we always look into the principles of natural justice. So the work or job of law is to look into the effect what is there on the society. Judges, they have to come out with a mission to see whether the needs of the society are fulfilled or not. Judges, they are acting as a protector. Judges are acting as a promoter. They have seen the needs of the society. But here we find that to fulfill the needs of the society, Professor Jerome Frank, when he spoke about that there are two types of persons or people who are there. They are, he means to say about the judges, two types of judges. They are rule skeptics and fact skeptics. So skeptic is a person who is inclined to question. A person who questions the validity, a person who questions the authenticity of something purporting to facts. So he says that there are two kinds of judges which are there. So some are called as rule skeptics, some are called as fact skeptics. So rule skeptic people who are there, they rely on the rules or test the law on the rule. They do not take into account the fact. So they ignore the fact. And actually, whatever is the decision which is given by the judges, it is a set of facts which give rise to law. So that's why we say ex facto obiter jus, which means law emanates from facts. Facts becomes equally relevant and important. Okay? But there are some judges, they will only follow the rules and rules. So let us take an example of Indira Gandhi's assassination case. So where you can find the evidence which was available was that Keher Singh, he traveled from Amritsar to New Delhi with wife of one of the accused in one compartment. And only that was the evidence. And on the basis of that evidence, Keher Singh was sentenced to death. Okay. So let 100 people go or remain scot-free, but one innocent should not be punished. And due to the elusiveness of fact, due to uncertainty of fact, ultimately the decision, it got affected. And it was stated that it was a judicial murder, just like Raja Nandakumar trial, which could be equated with Keher Singh. So one of the members of the Constituent Assembly commented on that particular issue on Keher Singh's decision. And he stated that even the dog could not be convicted on the basis of the same evidence. So the judges have only taken into consideration the facts. They have not equated it with the rules. So the fact skeptic is confined only to the facts. But what is important for the judges is firstly framing of issues on the basis of the facts. Then we should, for which it says, Jerome Frank says that we should give training to the judges, because judges ultimately they have to adjudge, and it has to be done in an impartial manner. So it is, and then only it could be possible for the judges to deliver justice. And judges, they do play a very pivotal role, and therefore it is necessary that the judges should be given the proper training, and there should be the combination of the facts as well as the rules. Professor Frank says that we always rely upon the text of law, and therefore he calls it as a textbook approach. And therefore he says that he has objected that textbook approach, because textbook approach is merely you are reading that law, merely you are reading those sections, merely you are reading those provisions, and that is not enough, that is not sufficient, and sometimes those they could be misleading one. So where could we find the certainty of law? So in a judge, but not in all judges. So what are those judges where you could find the certainty of law? And naturally they are the fatherly figure judges, those judges who are having a creative mind, and because of which it has become possible for them to interpret the law, because of which it has become possible for them to decide the case, and also to lay down the principle. And that's why I have given an example of Chief Justice Y.V. Chandrachud, how he has interpreted Shahabanu. Okay? Or fatherly figure judges, they establish a certainty of law. Even Justice Kuldip Singh, who spoke in Sarla Mugdal about the Uniform Civil Code. So there are extraordinary judicial techniques, because justice have to be done. They have to rely on the text of law, and the text of law should be rational, reasonable. It could mold the law so that there will be proper justice which could be done. Now, Carl Levling says that he describes law as an institution, which means that law has to carry out number of jobs, number of activities, just like an institution, but it should be an organized activity. And law has a cluster of jobs. So in that institution, there are organized activities which shall be carried out. Okay, so judges carry out those activities which are of two types. So one type of judges which are there who are the slaves of the precedent. So Article 141, who adopt the slavish approach. So these are the similar facts, similar situations, but they don't take that there could be something different. So like, for example, if you are going through a divorce process or a divorce case is there, the facts are very, very important. So, and those facts could undergo change. Or for example, when there is a sexual harassment at workplace, facts are very, very important. So there are some judges who do not follow precedent in rigid manner, and that is very, very important. So if precedent is followed rigidly, then it may not be possible to counter the difficulties in society. So and that's why this example that Maneka Gopalan to Maneka Gandhi. No doubt that judges are human beings on one hand, and judges are also semi-god, because we consider judiciary as the temple of justice, and the task of judges is very, very difficult. But what Carl Levlin says, that despite of this, Carl Levlin says that the philosophy, the upbringing, the education, which also influence his or her decision making. Because no human mind is a piece of blank paper. However, we say that the judges are impartial, but what is the reality? The reality is that their philosophy, their upbringing, their education, it has influenced their decision. Justice Krishna Iyer's judgment, we find the flavor of Marxist philosophy. So it all depends upon what kind of background the judges have come from, what set of circumstances they have come from, how do they commit themselves to their ideology. These are the inner implied factor which influence the decision-making process. So ideology plays a very important role. For example, you might have heard about breakfast theory. So a good judge who is a married judge, and at the breakfast table, he has a fight with his wife. He's a family judge. He goes into the courts of law and he is hearing the matters. So that impact might be there. That maybe the wife of the judge is a nagging wife. So that impact is going to remain. Okay. Carl Levlin has referred two types of judges, which is known as a formal style judge and a grand style judge. So he says that judges who act according to formal style, they rigidly apply the doctrine of precedent. When they find facts are similar to past, they give decision on the particular whatever is the situation. So merely they might be fulfilling the formalities. But there are some judges who do not stick up to the doctrine of precedent. They differ from the past judgment, and they have a great style, which is known as a grand style. That's why Justice Chandrachud, Justice Mishra, we find that these are Justice Bhagwati, where we find that they have the grand style because they create new law, because they create new precedent. And new law is required because of the survival of the society. And it is the prime aim. It is a social need which is to be fulfilled. And we know that the journey of Shaka versus State of Rajasthan, which is the instance, which is the example of judicial activism, judicial creativity. They don't rely on the past judgment, but they have laid down the parameters because facts and circumstances demand so. Of course, in 2013, we do have the law, the legislation enactment, but whatever were the guidelines which were laid in Visakha versus State of Rajasthan, they are also followed. We know that such trend, which is also emerged in India as a product of judicial activism, and let us see how the impact is there of American legal realism, where we see on the Indian legal system. So we have cases like Mohini Jain, where right to education was held as a fundamental right. Of course, Article 21A is been now there. Unikrishna, right to compulsory education till the age of 14 years. Or the Rudul Shah's case, where we speak about compensation, how it is to be given, or even the Nilavati Behra's case, where we speak about the compensation cases. We have learned about MC Mehta and especially Asiad workers case. Vishakha is a very clear-cut instance. So even in the absence of any law, law was created by judges, guidelines were laid down which shall be followed. Not only that, but we know that while learning Article 12, we have learned about Bodhisattva Gautam's case, where we have learned that how the private individual has been also held as a state, because it says that unless the context, so you give the meaning to the term context. So if the context demand, anybody could be stated as a state. So realism is been viewed as an instrument of social welfare. Realism is being viewed as an instrument of social justice, which is taken into consideration. And that is the reason where you can find that realism does play a very important role. So we know that here, while speaking about realism, we know that a judiciary is an independent body. The judiciary is even-handed body. Judiciary is unbiased, and its function is to function within the framework of the Constitution. It has to interpret the Constitution. It has to support the rule of law. It has to, but in that we find that there is judicial activism. So the judicial activism, even though it is there, it is evolved through the process of judicial review, but we know that it has played a major role. So judicial activism, where we saw some of the cases, but two things which are very, very important in India. A court is engaged in altering the power which is related to make them more equitable, and that is a positive activism. A court is using its integrity to maintain the status quo in power, in relation, where they have found that there is no such negative activism which could be there. So where you find that, that's why Keswananda Bharti, or therefore where we have learned about Husainara Khatun, or where we have learned about Sheila Barse versus State of Maharashtra. So, or where we have learned about Sunil Batra versus Delhi administration, or where we have learned about Advocates on Record Association versus Union of India. Or we have also gone through the cases like Christian Medical College, Vellore, and others versus Union of India, where we find that these are all the cases where judicial activism is seen, because we find that the laws which were enacted by the competent sovereign legislative authorities were not sufficient, and therefore therefore American legal realism has the great impact on the Indian legal system. Now, when there is a great impact, we know that judiciary has played an important role. It is playing an important role in upholding and promoting the rights of the citizen in a country. The active role of the judiciary is to uphold the rights of the citizen and to preserve the rights of the citizen within that framework of legal system of the country. And therefore, you find that judicial activism is seen as a great success. And that is the reason here we find that the law enacted by the competent sovereign legislative authorities were not sufficient. And that's why a theory to a reaction to this is known as American legal realism. Here I would like to stop. Are there any questions?
There is no question in the chat box.
Oh my God. So I don't know whether it was in the chat box. I can see one question.
Mr. Ganesh?
Yes.
Yes, sir.
I think if there is no question, so we can conclude if Madam permits.
Yes, I have no problem, sir. I think
Thank
they have understood everything, and therefore there are no questions.
Yeah. Right.
Thank you so much, ma'am, for giving lucid presentation and valuable insight on the topic American legal realism.
Thank you. Thanks.
It's my privilege to have been asked to propose vote of thanks on this occasion on behalf of MP Law College and entire legal fraternity of this institution. At the outset, I thank our chief guest and resource person, Dr. Tejaswini Malegaonkar, ma'am. We are really enlightened with your knowledge and presence. I extend my most sincere thanks to our respected principal, Dr. C.M. Rao, sir. I am also thankful to Vice Principal, Sri Kishan More, sir, IPSC Coordinator, Dr. Aparna Kotapalle, ma'am, and faculty in charge, Dr. Amul Chavan, sir, for their enthusiastic support. Last but not least, I sincerely thank all the teaching and non-teaching staff, staff technical member, and all dear attendees. Once again, I thank one and all. Before ending this session, I request to all the attendees to remain present tomorrow at the same time for the next session. Dr. Vivek Dubdale, sir, Head of Department of Law, Shivaji University, Kolhapur, will be guiding and enlightening us on the topic natural law theories. Thank you, one and all.
Thank you, madam.
Thank you, sir. Thank you so much for inviting me. I hope it will be useful to all the students. Thank you so much.
Yes, definitely.